Good morning, Your Honors. The matter before the court this morning is the case entitled Jennifer Knapp versus Timothy Dasler, case number 23-AP246. Appellant Timothy Dasler is self-represented. Appellee has not participated in this appeal.
Okay, thank you very much. Mr. Dasler, can you hear me, sir?
Yes.
All right, and we can hear you. You understand you have 5 minutes?
Yes.
All right, please proceed.
Thank you. First, I'd like to address visitation rights. Section 668A requires a hearing within 30 days of a motion to enforce visitation. The court failed to hold a hearing, which appellant is entitled to. Second, the court ordered parent coordination as an alternative and said that any lost visitation could be addressed there. It denied appellant's motion to reconsider and did not acknowledge his argument that he was unable to afford the fees for parent coordination and that he had a right to a hearing. Since the court appeared to be confused and did not acknowledge his key arguments, he filed a second motion to reconsider. On December 20th, the court issued two diametrically opposed orders, one denying appellant's motion to reconsider and the other denying appellee's motion to enforce parent coordination. One order said the court lacked authority to order parent coordination when appellant opposed it and could not afford it. The other denies appellant's motion to reconsider, which argued parent coordination was inappropriate for precisely that reason. This contradiction needs to be addressed. If the court's prior resolution was beyond its authority, then it must resolve the issue, and the statute still requires a hearing. Third, the court's reasons for the appellee's failure to provide visitation are not within the narrow exceptions in 668A. Thus, the court lacked authority to deny a hearing. Appellee's right to claim summer vacation is only valid when claimed within certain time limits. Outside those limitations, she may only select vacation by agreement of the parties or a subsequent court order. Emails from appellee and those from her attorney show an intent to withhold information about summer childcare, which appellant was already entitled to, and use that as a bargaining chip to force him to waive his right to select summer vacation dates of his choosing in even years, when his schedule must prevail according to the terms of the 2018 divorce order. No reasonable court should accept this sort of gamesmanship, which is a clear violation of the order. When appellee withholds the child's records, she is violating the order. Her attempt to force appellant to waive his right to select summer vacation dates of his choosing in even-numbered years undermines the guidelines designed to prevent this sort of disagreement. When her bad faith tactics failed, she doubled down with another violation by simply giving him 10 days notice that she was usurping appellant's parenting time for a week-long vacation. Again, this is inexcusable, but also fails to meet the factors in Section 668A for depriving a parent of visitation. Without either court permission prior to the vacation or agreement of the parties, appellee's vacation was unlawful. Fourth, I'd like to address the child's records and care providers. The court erred in failing to restore appellant's equal access to records. He is entitled to access these records and be both informed of and involved in the child's major decisions. Appellant's own emails show her intentionally withholding records of summer childcare providers as a bargaining chip, and she must be ordered to provide equal access, not use access to records as leverage. Appellee continues to conduct medical appointments in secret, perpetuating a change to the child's medical care that fully excludes appellant from both decision-making and information about care. If the state delegates a parent as gatekeeper of the other parent's rights, it may not also abrogate the responsibility to ensure that power is not used to sever those rights without a hearing. Failing to enforce allows her to use state power to sever the father and child's rights without a hearing, in violation of the father and child's 14th Amendment rights. And lastly,
I'm sorry to interrupt you, but is the complaint that that you weren't provided the records, or is the complaint that you weren't provided with consultation?
No, both to some degree. Basically, she scheduled summer childcare, which she's obligated to do, but did not provide any information. So for me to schedule my work, I don't know if I'm going to Woodstock, Vermont or Thetford, Vermont. I don't know if it starts at 8 or 10 or 9. I don't know if there's care at all. So I can't schedule my summer work without that information. And her withholding it was deliberately to provide, to compel me to move my vacation. And again, it doesn't matter whether or not, so I have no.
You have 1 minute, sir.
Oh, sure. And then lastly, the 2018 divorce order requires that parents meet at least once annually to discuss the parenting plan. It was intended to be modified regularly to meet the child's needs, but hasn't been modified for 6 years because Ms. Knapp refuses to meet and the court has not enforced it. The needs of a 2-year-old child are very different than those of an 8-year-old child. The court's order does not address this request, and enforcement of this provision is in the child's best interest. And in conclusion, the court's disregard for rules and statutes throughout this case are well documented, including prior appeals. But you can see from in 2022, the court said the motion was not an emergency, but in 2023, it said it was moot, even though he's still entitled to access the records and make up parenting time. The diametrically opposed orders in December 20th, similarly, really can't be excused. The court understood the argument should have prevailed, but then denied it and ignored that the argument existed so that it could simply deprive him of those rights. Judge Gray has rotated out of family court in Windsor, and at this point, a new judge should take up the case, which has never gone to a hearing. And that seems to be a reasonable resolution to prevent a perpetuation of these sorts of errors.
Okay. All right. Your time has expired. Thank you very much. So please.